and see if we can do as many of those people and get that, clear the court, as much of the courtroom as we can before 2:30. And then at 2:30, maybe we can stop and do the one hearing, if that's okay with the court. I don't know.
That's fine with me, Your Honor. That's what we discussed earlier, is we could try to get some of the out-of-custody clients out of here. If you'd rather just do the pretrial detention, that's fine with me.
That's also fine, Your Honor, whichever way.
So what are we doing on the other two pretrial detention hearings?
The state will be requesting a continuance on Howard.
What
And then
about
Be-
Bessinger?
Bessinger's, the defendant is stipulating to the state's pretrial detention motion is what Mr. Medina said.
I've got a note that the victim is appearing on via Zoom.
She was, Your Honor, if she was gonna have to testify. I think because there's gonna be a stipulation to the pretrial detention motion, I don't think she needs to anymore.
Okay, let's do those two first, and then we'll hold on Camarda. Let's try and see what we can get done on the arraignments.
If we can handle Mr. Howard first, Your Honor.
Okay, let's do Mr. Howard.
Mr. Medina's not here yet. And then Madam Interpreter asked if we could take her one case with
Yes.
us.
You want to do that first?
I would love to, Your Honor.
Yeah, let's do that. That's what I meant to do. Gonzalez Rodriguez.
Yes, Your Honor. Should be Erlin Gonzalez Rodriguez.
Okay.
Do you want me to swear the research?
Yes.
Do you swear or affirm that you make an accurate, complete, and impartial interpretation from the Spanish language into the English language and vice versa relative to the cause now under consideration before the court?
I do, thank you.
Is she an inmate? Is it he or she?
It's he, Your Honor. It's Mr. Erlin Gonzalez
an inmate?
Rodriguez. Yes, Your Honor. He should be in custody.
I don't show him.
It shows on how they have custody.
Mine also, but that doesn't mean it's not, but.
And it was transported if he is, because he's not on transport list.
Can you check the jail? See real quick whether, can you check it, Mr. Gates, if he's in?
Quickly as I can.
Take your time. Tell you what, why don't we pass over this, but we're gonna come right back to it. Let's go ahead, we've got a couple we can,
Your Honor, I still show that he's in custody.
okay.
We can handle this case, Your Honor. I can enter not guilty on his behalf. Anyway, and the state had stipulated to modifying the bond in his case, to get him out, so that would have saved him a trip anyway, Your Honor, if we can approach with that order.
So why don't you just go ahead and announce it and?
Yes, Your Honor. We'll be entering a not guilty plea at 24 CF 2316. And then I have a bond order, the state's stipulating to modify the bond to signature bonds.
Yep.
The thinking being is that Mr. Gonzalez has an ISOL, and so we want to kind of trigger that and see if we're going to take him or not.
Right. And so when do you want to come back? Is that the?
Given that it's a signature.
12-9?
12-9, Your Honor. Yes, Your Honor.
Okay, so we'll continue until 12-9.
Thank you, Your Honor.
Thank you, Ms. Teresa. Counsel?
Yes, Your Honor, this is gonna be Mr. Derek Howard before the court. I think the state's probably got a case on, I don't.
Case number is 24CF2623.
Correct.
Your Honor, the state is requesting a one-week continuance. We received this case yesterday, and we have made several attempts to contact the victim this morning. However, we have not been able to get a hold of her. So we're requesting a one-week continuance in order to speak with her and determine how we're going to proceed with pretrial detention.
Counsel?
Yes, Your Honor. Obviously, we would object to the continuance, but I understand the state does have the right to request it. I would put on the record, Your Honor, Mr. Howard is currently on probation for an unrelated matter, and so this won't violate that probation, but there are things out there that'll keep him in line and keep him in check if the court was to set a bond next week.
Until we know differently, I think it's a fairly rote request by the state.
Yes, Your Honor.
And I think they have a right to continue it for a week.
Yes, Your Honor.
At least. So we'll continue this matter until, be continued.
November 21st.
What is it?
November 21st at 12:30.
November 21st, 2024 at 12:30.
Are you formally appointing Mr. Gates to the case, Judge? Because I don't show that he's been appointed.
The public defender is appointed. Thank you.
Thank you, Your Honor.
You want to do Bessinger?
Yes, Your Honor.
It'd be just a moment, Judge, you have to run downstairs and back up.
Very good.
I just heard the elevator, so. Come out to the podium, sir.
Your Honor, Steve Medina with Paul Benton Bessinger in 24 CF 2533. We're here on the state's motion for pretrial detention, and I wanted to represent to the court on behalf of Mr. Bessinger that at this time, Mr. Bessinger was not going to oppose the entry of order for pretrial detention pursuant to the state's motion. I did want to state on the record that the statute that's involved, section 907.041, subsection 5, in paragraph N of subsection 5, specifically provides the defendant shall be entitled to dissolution of the pretrial detention order whenever the court finds that a subsequent event has eliminated the basis for detention. There also may be constitutional arguments. I know this court has, prior to today, in other cases, heard various constitutional arguments relating to, for instance, the pretrial detention statute may not be consistent with Article 1, Section 14. So we would reserve all those arguments and not need to raise them today, and are not opposing the entry of the order at this time. Just for to amplify a little bit, is that we're just beginning the discovery process, Your Honor. The state has turned over some evidence. We'll be reviewing it and beginning our own investigation and so forth, and then we'll go from there, Your Honor.
State.
Your Honor, the statute does state what Mr. Medina just recited for the court, and obviously the state doesn't object to the entry of the order for pretrial detention. And the state has filed an information, so I don't know if Mr. Medina wants to go ahead and do a plea.
We will enter a not guilty plea at this time, Your Honor. And was it based for the same charges that he's being held for?
Yes.
Okay, thank you, Your Honor. Enter a not guilty plea. And if we could, I think, put him on the December pretrial docket unless the court deems otherwise appropriate.
Court will accept the stipulation and order pretrial detention until further order of the court. We can come back on 12/11.
Thank you, Your Honor. Okay,
Or-
we haven't seen you. Thank you. Thank you, Your Honor.
Thank you. Okay.
If you have Medina with a public defender, that's Adam.
Okay, the next portion of our hearing is going to be arraignments. The purpose of the arraignments is merely to enter a plea. That's the purpose of today's hearing. It's the first, it's kind of the start of the criminal process. Some of you are here without an attorney, and I'm specifically addressing you. Those of you who have an attorney, I'm sure are discussing these things with your attorney, and you understand what's going on here today. Those of you all who do not have an attorney may not be as familiar, and so I'm stating it for your benefit. First of all, first thing I would say to you is you have a right to have an attorney when you have a criminal charge such as this alleged against you. So the first thing I'm going to do when we call your name, you can come down to the podium. I'm going to ask you whether you wish to have an attorney. And at that point, what I'll do, I'll just enter a not guilty plea and allow you to meet with your attorney. We can come back in the next cycle, which is next month. After you talk with your attorney, you can look at your different options, okay? The state may make you an offer. You're not under any obligation to accept it. Again, purpose of today is just to enter a plea primarily, and if you don't have an attorney, to have an attorney appointed. So you're not forced to have an attorney. You're not required to have an attorney, but I can assure you, I strongly recommend that you have an attorney, either a public defender or a private attorney. And also understand when you're being asked, do you wish to have a public defender appointed? If there is a public defender appointed, you always have the right at any point to substitute with a private attorney. So there's no downside to accepting the appointment. You will have to fill out the forms and turn them into the clerk's office to make sure you qualify for a public defender. But there is there's really no downside, and it's certainly a great upside to have an attorney, either a private or the public defender. So with that, the court's going to begin to call the cases. Okay. You want to just start from the top? You want to do yours, Mr. Gates? It looks like you're first up here. You want me to do some out of, or we can do some no attorneys?
The court will allow me to call my two, that may make it easier, and then we can review.
Okay.
Unrepresented at that point, I can.
That'd be fine, sure. So,
My first one's gonna be Bonnie Humpert, Your Honor, Humpert, for the court 24 CF 2210. So the state inclined to keep that offer open, we discussed yesterday, she wanted some time to think about it.
Yes.
If we can enter a not guilty plea in Ms. Humpert's case, the state did make her an amended offer. They've agreed to keep open to December the 9th for her to think about.
very good. We'll enter a not guilty plea on her behalf, and we'll continue this matter until December 9th at 9 a.m. Stay in touch with your attorney in the interim, ma'am.
Thank you.
Your Honor, next I've got is Matthew Keel. It's K-E-E-L. Mr. Keel is before the court in 24 CF 2295. At this time, if we can enter a not guilty plea on his case, he's currently scheduled for December the 9th.
Very good. The court will enter a not guilty plea, and we'll continue the matter till December 9th. Okay. You want me to try and do your cases with no attorneys appointed? Your-
I would just do the other representing Your Honor, and I will hand out
Okay.
cards and try to get applications filled out.
Very good.
Oh, Mr. Medina's back in.
I have a couple of out of custody.
You want to do those first or without attorneys? Go ahead, call them out.
Whatever the court's pleasure.
That's fine. Go ahead and call them out, Mr. Medina.
Can I call Alex Adams, please, Your Honor? Your Honor, Steve Medina with Alex D. Adams in 24 CF 2256. And at this time, Your Honor, Mr. Adams is going to enter a plea of not guilty, and we would like to remain on the December 9 docket. And I'm giving him my card with my assistant's name on it so he can set an appointment. And he does need an application. So you're going to fill out one of these applications before you leave the courthouse and turn it in to the clerk on the first floor, sir. Thank you.
Okay, so we'll accept the plea of not guilty for Mr. Adams, and we'll continue this matter until December 9th at 9 a.m.
Thank you, Your Honor. Next is Autumn Bell. Ms. Bell is approaching, Your Honor. Your Honor, Steve Medina for Autumn B. Bell. B as in boy, 24 CF 2410. At this time, I would like to enter a not guilty plea for Ms. Bell. I'm giving her my card with my assistant's name on it, and she's going to fill out the application and turn it in on the first floor, okay? Is that an appointment?
So we'll enter a not guilty plea and continue the matter till December 9th at 9 a.m.
Thank you, Your Honor. And my other out-of-custody client was Joseph Anthus, but I'm looking for that individual, Your Honor. We may pause for a moment. I'll keep looking.
Is Joshua Anderson here? Would the state announce?
Yes, Judge. 24 CF 2376 is defendant Joshua Anderson. We have the charge is a third DUI and leaving the scene of accident.
Mr. Anderson, as I mentioned, you do have the right to have an attorney appointed. Are you going to wish to have me appoint the public defender, or are you going to hire private counsel?
I can appoint the lawyer.
Okay. Court will appoint the public defender. Court's going to enter a not guilty plea. That'll preserve your rights. We're going to come back on December 9th at 9 a.m. In the meantime, between now and then, meet up with your attorney, figure out, look at your options. Okay? Anderson is, who has A's?
Oh, sorry, that's Steve.
Wake up there. Hold on, Mr. Anderson. Ms. Farkas, do you wish to do your out of custody?
Sure thing, Your Honor. The first one I have is Tracy Culbertson, 2024 CF 2278. He is present and approaching. The state and the defense have reached an agreement in this case, if I may approach.
You may. Thank you. Would you announce, please?
Yes, Your Honor. There are two counts here. Count 1 is possession of controlled substance. Count 2 is possession of paraphernalia. There will be an adjudication of guilt in both counts. Mr. Culbertson will be sentenced to credit for time served, court costs, public defender fee, and 24 months to pay those costs.
State?
That is the agreement. Score sheet will be provided at a later date.
It's not a downward departure, though.
Correct.
Very good. Mr. Culbertson, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir, I do.
So you heard your attorney state the terms of the plea agreement, pretty straightforward. You can put your hand down. I see you've signed a plea agreement that says the same thing. Have you gone over this plea agreement with your attorney? Make sure you had all your legal questions answered?
Yes, sir, I do.
Because you're waiving the right to go to a trial in order to get this totally resolved. Is that what you want to do?
Yes, sir,
And you're entering this freely and voluntarily?
I do.
Okay, very good. Based upon that, the court will accept your plea as to both counts. The court, there'll be an adjudication of guilt, and your technical sentence is credit for time served, so you'll be done, no probation. And the court will assess $615 in court costs, $150 public defender fee. You will have 24 months to pay those before they go to collections, okay?
Yes, thank you, Your Honor.
Good luck.
Thank you.
You're good to go. Oops, wait, sorry.
Ms. Farkas, what's your next one?
Everett Howard.
Okay?
Your Honor, this is Everett Cowart, 2024 CF 2199. His arraignment was reset. There had been a KBS issued, but then it was recalled. I believe Mr. Cowart was in a rehabilitation facility. So we're here now on his arraignment. He'd like to enter a plea of not guilty. I think he's already on the 12-9 docket.
Very good. Enter a not guilty plea and keep him on the December 9th docket.
Thank
9
you, Your
o'clock.
Honor.
Meet up with your attorney in the interim, okay?
Your Honor, I have George Durell is not present. It's a waiver. I'm not sure if it fell off the docket.
There is not a Durrell on my docket.
And then I have Samuel Eves, 2024 CF 2330.
Okay?
He is present and approaching.
Would you announce the case?
Yes, sorry, 2024 CF 2330. There's one count of possession of a controlled substance. Thank you. Okay, so Your Honor, we're going to enter a plea of not guilty today. There is an offer from the state attorney. I would just want to confirm that it'll stay open.
It will stay open.
Okay, thank you. I think he,
Court will enter a not guilty plea and will continue this matter until the next cycle, 12/9 at 9 a.m.
Okay, thank you, Your Honor.
Meet up with your attorney in the interim.
I believe that's all of my out of custody clients.
Okay.
Your Honor.
Let me just get a few.
Oh, I'm sorry, I did miss someone, I'm so sorry. Nicholas Carasso III. Sorry, I just thought I was hiding. He's present and approaching, 2024 CF 2314. Mr. Carasso would like to enter a plea of not guilty. He's already on the 12/9 docket.
Very good. The court will enter a not guilty plea and continue until 12/9 at 9 a.m. What about Arthur Cheever, Ms. Farkas?
Your Honor, I was under the impression that he was at the jail. He must have been released. Oh, he's here. That's great.
There you go.
Hey, Mr. Cheever, come on up. Your Honor, this is Arthur Cheever, 2024 CF 2391. Mr. Cheever would like to enter a plea of not guilty. He's already on the docket for 12/9.
Very good. The court will enter not guilty on his behalf. We'll continue this matter until December 9th, 9 a.m. Meet up with your attorney in the interim. Let me go through just a couple that appear not to have attorneys. Is Mr. Trevon Cooper here? Trevon Cooper, 24 CF 2374.
Yep, Judge, that was no crossed 11/12.
Very good.
The reason is
That's fine.
he's relinquished to the jurisdiction.
Trevani Cowell. Would the state announce?
Yes, Judge, this is Trevani Cowell, 24 CF 2345. The charges are possession of controlled substance and POP.
Very good. Mr. Cowell, do you wish to have an attorney appointed as first order of business?
Yes, sir.
We're going to hire private counsel.
Attorney.
Okay. Court will appoint the public defender. As I said, I'm going to enter a not guilty plea on your behalf so that you can have a chance to meet up with your attorney. And we'll continue this matter until December 9th at 9 a.m., okay?
All right, sir. Thank you very much.
Okay. There's, get your card, that's your contact information. Is Rocky Davidson here? Come forward, sir. Would the state announce?
Yes, Judge. This is Mr. Rocky Davidson, case number 24 CF 2379. The charges are insufficient funds. He passed the check.
Mr. Davidson, you do, as I said, you do have the right to have an attorney appointed. You wish to have an attorney appointed, you're going to hire private counsel.
No, sir.
No what? No on
no
either side?
attorney.
Neither on either side, okay.
So
State?
I had the pleasure of speaking with Mr. Davidson, I believe yesterday or the day before. Him and I discussed an agreement. I'm going to pass the agreement to Mr. Davidson.
Okay,
I'm not able to advise Mr. Davidson on what the agreement says, but if we can pass him so he can review it.
okay. Mr. Davidson, why don't you take a seat, kind of just grab that with you and just look it over, and we'll come back and see if we can get it resolved, okay? What did we do, Ms. Farkas, with Isaac Dumas? That's an out of custody that's got your name next to it.
Your Honor, this is Isaac Dumas, 2024 CF 2369 and 2024 CF 2381. I apologize, I passed Mr. Dumas, he was sitting in the back. If we could enter pleas of not guilty in both cases, he's already on the 12/9 docket.
Very good. We'll enter a not guilty plea and we'll continue until 12/9 at 9 a.m. Get up with your attorney in the interim.
Thank you, sir.
Jasmine Hughes. Jasmine Hughes. Would the state announce?
Your Honor, this is 24CF2333. The charge is possession of a controlled substance.
So, Ms. Hughes, as I said before, you do have the right to have an attorney. Do you wish to have an attorney appointed?
Yes, sir.
Okay. The court's going to appoint the public defender, and as I said, I'm going to enter a not guilty plea on your behalf. That'll preserve your rights so you have a chance to meet up with your attorney. We're going to continue this matter. The next hearing will be on December 9th at 9 a.m., but in the meantime, meet up with your attorney and fill out that application, okay?
Yes, sir. Thank you.
Thank you. Leanne Josephson.
Your Honor, this is State versus Leanne Josephson, case number 24CF2334. Charge is possession of a controlled substance.
Ms. Josephson,
Yes, sir.
you do have the right to have an attorney, as I mentioned. You wish to have an attorney appointed?
Yes, sir.
Court will appoint the public defender. Court will enter the not guilty plea, as I mentioned. We'll continue this till 12/9 at 9 a.m. Give you a chance to meet up with your attorney. Which one is Mr. Gates?
Thank you.
He'll give you a card and come back. Chad Krivek.
Your Honor, this is State versus Chad Krivek, case number 24CF2359. Count 1 is insurance fraud, more than $100,000, and count 2 is perjury.
Okay, Mr. Krivek, you do have the right to have an attorney appointed with these charges. Do you wish to have an attorney appointed, or are you going to hire private counsel?
I wish to have a attorney appointed.
Okay,
right
court
now.
will appoint the public defender. You still got to fill out the application fee. I'm going to go ahead and enter a not guilty plea. That'll preserve your rights. And we'll come back on December 9th at 9 a.m.
Okay.
Okay?
All right, thank you very
You can
much.
get that. Your attorney will give you the card. That'll be your attorney, and he'll, okay. Is there anybody else out in the gallery that thinks they have a hearing today? What's your name? Come on up, come up. Then I'll get to you, sir. What's your name, sir? Okay. That's Mr. Medina's case. Okay. We'll let him know you're here. Go ahead. Go ahead and take a seat because your attorney is out talking with somebody. We'll take your case in just a second.
Judge, could we recall Mr. Rocky Davidson?
Let's get this one and then we'll get Rocky.
Yes, sir.
Yes, sir. What is your name, sir?
Peter Folta,
How do you spell your last name?
Folta.
What's that?
I don't have that one, Your Honor. on
The
my-
clerk has informed me that that case, what's the case number, ma'am?
24CF2289. It was no frost.
State null pros, they dismissed it. Apparently somehow you didn't get the word.
Okay, thank you, Your Honor.
No, it's not bad news, so. Okay.
If we could recall,
Mr.
Mr.
Davidson.
Rocky Davidson, 24CF2379. The defendant and the state have reached an agreement.
Okay,
That agreement is gonna be, a withhold of adjudication, 3 years probation. He may terminate probation after the completion of all terms. He's gonna complete an anti-theft course, and the defendant shall pay restitution in the amount of $6,535 to cooling and heating. That's gonna be located at 70 Eglin Parkway in Fort Walton Beach. And the minimum payments per month for that restitution is gonna be $200.
okay.
And that is the agreement, if I may approach
You may.
after I sign
Give
it.
me a second, I'll ask you a few questions.
Have the agreement, Judge.
There you go. Okay. Not a downward departure, I assume. So, Mr. Davidson, let me swear you in so you can answer a few. Did I swear you in already?
Yes, sir.
Okay, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
Okay, so you heard the state. Now, the state's not your attorney.
Yes, sir.
They're representing the state of Florida. But you heard the attorney state the terms of the probation, pretty straightforward. Probation plea agreement. And just want to make sure that you are comfortable, even though you're not an attorney, you're comfortable that you understand the process enough that you would enter into this plea agreement based, without having basically the ability to talk with an attorney about it.
Yes, sir.
You feel comfortable with this, you believe?
Yes, sir.
Did you get a chance to kind of read through this plea agreement?
Yes, sir.
One of the big things about this, by entering this plea agreement, it says sentence recommendation, but they should relabel that, it's actually a plea agreement. By entering into this, you're waiving the right to go to a trial. You have a constitutional right to go to a trial, force the state to prove their case beyond every reasonable doubt. That's your right. You're waiving that in order to get to this plea agreement. Just want to make sure you're comfortable doing it. You do have a right, if you want to consult with your attorney, they'll leave this plea deal open. They're not going to shut it off, but if.
I'm comfortable.
You're comfortable? Okay. Very good. Based upon that, then, the court will accept your plea. The court will sentence you to 3 years probation. When the state says may terminate after completion of all terms, what are the terms that, just so he's clear about that?
It would
Is
be
it
all-
mainly the restitution?
It's the restitution and the anti-theft course.
Okay. But it doesn't have the anti-theft.
It is,
Is it hiding in here somewhere?
it's on the first page.
Okay, gotcha.
Thank you, Judge.
Okay. So you got to finish the anti-theft course, pay off the restitution, and you can apply to terminate the probation.
Yes, sir.
Okay, but if you don't, does it say, okay, $200 a month? But if you don't pay at least $200 a month, then you could be violated on the probation.
Yes, sir.
Okay? Any questions regarding that or anything regarding the plea agreement?
No, sir.
Okay. Very good. Good luck.
Thank you.
Thank you. Okay, anybody else who thinks they're, go ahead, Mr. Medina. That's all right, come on.
Could I call Tequan Ballard? Mr. Ballard
Sure.
is out of custody. He's
Yep.
with Tequan D. Ballard. Did I pronounce your, Taekwon, I'm sorry, sir. Ballard in 24 CF 2312. At this time, he would like to enter a not guilty plea. And if we could remain on the December 9, 2024 pretrial conference docket, and he's going to submit the clerk application before he leaves the courthouse, and I'm giving him my card.
Very good. The court will accept the not guilty plea and continue it until 12/9.
Yeah, whatever, And Judge, he does represent that it is no violent contact with the alleged victim in the case. It said at the conditions of pretrial release said NCWV unless V okay with then NVC. So it is no violent contact.
Okay, I didn't track what you were just
Okay,
saying. but
well-
Maybe you,
No, it said in the paperwork.
in what paperwork? What are you reading from?
Record of first appearance.
First appearance?
Yes, Judge.
Okay.
The record of first appearance, I'm just clarifying for the record that my understanding that not the alleged victim is here present and that she does want, and had already indicated that she wanted it changed to no violent contact, and that consistent with the paperwork that had already been the case. But just if there's any question by the state, it is no violent contact at this time. Otherwise, we can have her talk to the state, but she wants no violent contact, and first appearance paperwork said it was okay.
If it's been previously ordered, it's ordered. If it's
Well-
no violent contact, I don't know, I'm not looking at it.
I'm simply stating that it was to me, ambiguous enough to why I'm bringing it up, because I don't want there to be any misunderstanding, so.
State,
Can you see what it said? I've just never seen this kind of contingent, no violent.
I never have either, Your Honors. The state
there is no
has.
such thing as contingent, no violent contact.
It says unless a victim okay with it, then no violent contact.
So what's the state's position? They want no contact or no violent contact?
Your Honor,
Good.
I would have to speak to the victim really quickly, but I do believe that she does want no violent
So
contact.
Well, go talk to her.
just
She's
go
right
sit-
there.
Go sit on the third row over there while they go talk to your significant other, okay? Thank you, Your Honor. Appreciate it. I just didn't want there to be any ambiguity, so.
Okay, anybody else here in the audience that has a case before we start calling the inmates? Okay. Let's go ahead. You're right.
Your Honor?
Yes, sir. Yes, ma'am.
May I approach with score sheets from this
Sure,
morning?
sure. Okay, thank you.
Your Honor, we can readdress Mr.
Hold on a
Ballard
second.
whenever the court's ready.
Give me just a second. Ms. Giardini just overloaded me with score sheets.
Sorry about that.
Ms. Sharpless.
Yes, Your Honor, and in Mr. Ballard's case, again, that's 24 CF 2312, the state has spoken with the victim who's present in the courtroom, and she has indicated to the state that she does want contact with the victim, so at this time, this state would not oppose the court modifying the contact to no violent contact.
Well, it seems to me to be unclear about what was originally ordered, so I'm going to clarify what was originally ordered, so he's not arrested for violating it when he walked into the courtroom. So, court will clarify to make sure that it's made clear that Mr. Ballard may have no violent contact. That means you may have contact, but so long as it's not, if it moves to violence, then you're in double jeopardy, okay?
Thank you,
So
Your Honor.
you may have contact with the victim. the alleged victim.
Thank you very much, Your Honor.
Okay, so your deal, and you are finished because you entered your not guilty plea and you're coming back on 12-9.
All right, thank you. Appreciate it.
You want to start doing inmates? Let's do it. You want to start? Brian Baker?
You're-
Ms.
Judge, did you
Sharpless?
want to do the pretrial detention?
We could. Yeah, we can do
If,
that.
it's up to the court, but I know, again, I have an officer who needs to leave at 3, so if I can, we can go ahead and do it.
Okay, let's do it.
Thank you, Your Honor, I appreciate it. Yes.
So we're going to have the pretrial detention hearing, which is State v. Camarda. Hold on just a second, let me pull up the case. State may proceed with their motion.
Yes, Your Honor. This is 24 CF 2546, and the state has filed a motion for pretrial detention. Unless the court wants me to make some introductory remarks, I won't, I'll try not to recite my motion.
Your
but-
decision, counsel.
Yeah.
I've reviewed the motion.
Yeah. So, Your Honor, the state does believe that the defendant has been charged with a dangerous crime, that there's a substantial probability that he committed that crime, and that the factual circumstances of the crime indicate a disregard for the safety of the community, and there are no conditions of release reasonably sufficient to protect the community from the risk of harm. And the state would first call Deputy Timothy Hennis as its first witness.
Madam Clerk, would you please swear the witness?
Do you swear affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Good afternoon. Can you tell us your name and how it's spelled?
Timothy Hennis, Hennis.
Okay. And can you tell us what you do for a living?
I am a deputy with the Okaloosa County Sheriff's Office.
Okay. And were you so employed on the 3rd of November
I was,
of this year?
yes,
Okay. Were you on shift on that day?
I was.
Okay. Did you come into contact with Christopher Camarda that day?
I did.
Okay. Is Christopher Camarda in this courtroom today?
He is.
Okay, can you tell us where he's sitting and what he's wearing?
He is sitting at that bench right there in the middle, wearing an orange jumpsuit.
Okay. Your Honor, can the record please reflect that the witness has identified the defendant?
So noted.
Okay. Can you tell us how you made contact with the defendant?
I was dispatched to a reported call at Walmart, report of a theft. I was the first deputy to arrive on scene. The loss prevention officer, who was the original caller, identified Mr. Camarda as one of the suspects of retail theft. I approached Mr. Camarda, detained him for the theft investigation, and then shortly thereafter detained the other suspect involved, who was positively identified by the loss prevention officer.
Okay. So let's take a step back. So we have several Walmarts. Which Walmart?
I'm sorry, the Walmart in Destin, Florida.
Okay. And is that in Okaloosa County, Florida?
It is.
Okay. When you arrived on scene, can you explain where Mr. Camarda was when you detained him, and who is the other suspect involved in the theft?
Sure.
Suspected theft?
So as I arrived on scene, I exited my patrol vehicle near the exit to Walmart on the west side. Mr. Camarda was walking through the roadway towards aisle 2, which is where I ultimately made contact with him after he was identified. Made contact with him in the middle of the roadway on aisle 2, and then was directed to a red or maroon Ford F-150, where the female suspect, Ms. Bush, was located and positively identified by the complainant.
Okay. And who owns that red F-150?
Mr. Camarda does.
Okay. And so what occurred once your attention got pointed to the red F-150? What happened?
So I approached, located Ms. Bush, who was on the passenger side of the vehicle with the door open, detained her, informed her she was going to be detained for a theft investigation, sat both of them down on the ground as other deputies arrived, and then I proceeded to go inside and begin collecting necessary paperwork and evidence or from the loss prevention officer inside of the loss prevention office.
Okay. While you were gathering evidence for the theft investigation, did you gather any evidence that would corroborate the fact that that's Mr. Camarda's car and he was driving it this day?
I later learned that he was the primary driver from the co-defendant. We conducted a query of law enforcement databases, CIC, FCICs to be specific, with his tag number that was attached to the truck, and it came back registered to Mr. Camarda.
Okay. So once you actually detained them, you said they were placed on the ground. What occurred?
After that, we stood them up and we began interviewing them in regards to the theft. While we were interviewing them, we had a trained and certified narcotics detection dog arrive on scene, conduct a free air sniff of the maroon F-150 that belonged to Mr. Camarda, which subsequently we were informed of a positive alert from the K-9 handler,
Okay.
and we began searching the vehicle for narcotics.
Okay. And when you searched the vehicle, what did you find, if anything?
So we located paraphernalia, multiple items of paraphernalia in the vehicle, and then 2 magnetic black boxes underneath the vehicle, underneath the driver's side of the vehicle, stuck to the underside of the vehicle. And inside of that was approximately 148 grams of methamphetamine and 6 grams of suspected fentanyl.
Okay. Was there any other contraband inside those magnetic boxes?
I do not believe so.
Was Mr. Camarda also charged in this case with possession of a ammunition by a felon?
He was, yes.
Okay.
And we located that inside of the vehicle.
Okay. I think you already explained, so it was underneath the driver's seat, correct?
Correct.
Was this box locked or unlocked?
It was unlocked, but closed.
Okay. Once the drugs were found, what occurred?
So initially, we used a scale on scene that was located inside of the vehicle to get a approximate weight. We then conducted field tests of each individual bag of narcotics. I believe there were 3 tests for methamphetamine and 1 test for fentanyl. The 3 methamphetamine tests, were tested positive, presumptive positive for the presence of meth, and the fentanyl test kit tested positive for the presence of fentanyl for the 6 gram baggie.
Okay. What happened then?
So at that point, we began interviewing each individual person, trying to determine who the owner of it was. I interviewed the co-defendant in this case, and then another deputy interviewed Mr. Camarda in regards to it. And while we were in the process of determining all of this stuff, Mr. Camarda, his cell phone was receiving text messages from multiple different people. We confirmed it was his telephone, because when I detained him, he had the phone in his left hand. And Sergeant Bristol made contact with him in regards to the passcode for it, and Mr. Camarda entered the passcode and confirmed the phone was his.
Okay. Was there any other evidence that the court should know that the drugs belong to Mr. Camarda?
So we have video footage from Walmart of Mr. Camarda getting out of the driver's seat of the vehicle that we located the narcotics under. You can briefly see him crouched down on the driver's side approximately where the narcotics were located, and then he walked inside.
Once the drugs were collected and interviews were conducted, was there any further investigation done or business?
I'm not sure.
Okay. Was the, how did the drugs get packaged or taken to evidence?
Oh, I apologize. Another deputy took them to our substation, our Okaloosa County Stallman substation, where he reweighed the narcotics for an official weight with our calibrated scales in the office, which revealed that they were 148 grams of methamphetamine and 6 grams of fentanyl. And then he proceeded to package all of that in accordance with our policy.
After that, was there anything else any other investigation that was conducted besides maybe the defendant being placed under arrest and taking a booking? No.
I'm not sure.
Okay. Did you have body-worn camera on during this incident?
I did.
Okay. Your Honor, I'm gonna, can I approach the witness and show him State's Composite Exhibit 1? After I show him his purpose, of course. All right, Deputy, I'm gonna show you State's Composite Exhibit 1A through C. If you recognize those exhibits, will you look back at them?
Yes, these are all images of my body-worn camera.
Okay. Can you tell us what 1A is a image of?
So 1A is an image of the red F-150 in question that belonged to Mr. Camarda.
Okay. 1B?
1B is where we had the narcotics on the tailgate. The box was open, revealing the clear baggie that was contained the narcotics.
And 1C?
1C is the packaged narcotics outside of the black magnetic boxes.
Your Honor, at this time, the state would admit State's Composite Exhibit 1.
Defense?
No objection, Your Honor.
Without objection, the court will admit State's Exhibit 1A, 1B, and 1C.
Your Honor, may I approach the witness and get the
Sure.
exhibits for that? Your Honor, at this time, I have no further questions for this witness.
Ms. Farkas?
Thank you, Your Honor. Good afternoon.
Good afternoon.
I just have a couple questions. I apologize if I jump around a little bit. Excuse me. So did you speak to either my client or the co-defendant about a third person who had been in the car that day?
It was briefly mentioned that there was a third person involved in the retail theft.
Okay, and did you get a name or a description of that person?
I did not personally get a name.
Okay. And did you speak to either my client or the co-defendant about the truck in question being rented out to someone else or loaned out to someone else?
I did not.
Okay. When you were asking for the passcode for my client's phone, had you requested to search the phone?
So I did not request the passcode. That was a different deputy that was on scene that collected the passcode from the defendant. And I believe, from what I was informed, he said he wanted to show text messages.
I'm sorry, my client,
Text messages.
just to clarify, my client wanted to show text messages?
I believe so, but
Okay.
yeah, that was another deputy that took that.
Okay. So it maybe wasn't necessarily that he consented to a search, but rather was trying
I'm
to
not
show the
sure.
deputy something?
I'm not sure. I wasn't there for that one.
Okay. That is okay. Those are, oh, I'm sorry, one more question. The truck in question, was it towed from the lot, or was it left in the lot, do you know?
So we did not tow it. We left that up to Walmart. If they were going to tow it. I'm not sure after I left if it was towed or not, but we as law enforcement did not tow it.
Okay. And is that standard to leave it to the, I guess, the owner of the property there to tow the car?
Typically, yes.
Okay. All right, those are all my questions, Your Honor. Thank you.
Your Honor, I have no redirect.
Is the witness excused?
The state believes he may excuse. He's fine with the defense.
Thank you, sir. You are excused. Appreciate your help.
Thanks.
Your Honor, the state's next witness is Sergeant Jarrett Bristol.
Madam Clerk, would you please swear the witness?
Do you swear or affirm the testimony you're about to give will be the truth, whole truth, and nothing but the truth?
Please be seated, sir. Speak directly into the mic. It's very directional.
Yes, sir.
You gotta point right at it. You gotta lift it up. Yeah, there you go.
Hi, can you tell us what is your name and how it's spelled?
Jarrett Bristol, last name is Bristol.
And are you employed with the Okaloosa County Sheriff's Office?
Yes, ma'am.
That day you were the sergeant on scene, is that correct?
That is correct.
Okay. We've already talked to Deputy Hennison, established what you guys were doing at the Walmart. Did you respond to the Walmart that day?
Yes, ma'am.
Okay. Can you explain how you became involved in this investigation in regards to Mr. Camarda?
Heard the call over the radio. Due to the radio traffic, as a supervisor, I arrived on scene to see if I could assist with anything that those that were already on scene were handling, and then stood by and assisted with supervisor requirements.
Okay. Did you help search the car?
I did.
Okay. And while you were searching the car, did you discover anything?
No, ma'am, I did not.
Okay. Did you have obtained any evidence in regards to the defendant's phone?
Evidence in what way as far as the phone?
Did you make any observations about the phone?
Yes.
Okay.
He was receiving text messages, was also receiving Facebook messages to his phone while we were on scene.
Okay, and what were the content of those messages?
Many of the messages were indicating where the defendant might be, if he still had some, and a few messages came in that indicated I need.
Okay. Did you talk with the defendant this
I did,
day?
yes.
Okay. Was that because the defendant requested to speak to the supervisor?
The latter part of the total investigation, yes, he did.
Okay. And did the defendant confirm for you that that was his cell phone that was receiving the messages?
Yes, ma'am.
Okay. Was he trying to get a number or show you a text message from his phone? What was it?
Yes, he was.
Okay. Did you make any observations about if the defendant was worried about going back to jail?
Yes, ma'am.
Okay. Did he make any statements to you to that effect?
Yes,
Okay.
he was.
Do you remember the actual content of those
I
conversations?
don't remember the exact verbiage that the defendant used, but he did indicate that he was fearful of going back to jail, indicating that he could not go back to jail, that things were in place he needed to be a part of.
Okay. Your Honor, I don't have any other questions for this witness.
You wish to have any?
There's
You're getting
something
some
ringing.
noise. There's something beeping over in your area. Like a phone, some beeping's going off. Am I mistaken?
Looking at the contents of the cell phone, do you know which deputy was speaking with my client about the cell phone? About
I
retrieving the-
spoke to the defendant about his cell phone.
Okay.
I watched him unlock the cell phone in question.
Okay.
After he identified it, he was in the back of a patrol vehicle, he identified it, and then I placed it in a position where he could enter the passcode, to which he did.
Okay. And was this in the context of letting him know that you wanted to go through the contents of the cell phone?
No, ma'am. He
Okay.
requested to go through and open the phone so he could obtain a text message and a phone number that he urged me to call.
Okay. But he didn't consent to you searching the phone at that point?
Correct, and I did not ask to search
Okay.
his phone.
Okay. No further questions for this witness. Thank you so much.
Anything on redirect?
No, Your Honor.
Very good, thank you.
Thank you, sir.
Your Honor, the state has no further witnesses. The state would rest at this point and just make argument when it's appropriate.
Defense have any witnesses?
No, Your Honor. We'd also just like to make argument when time is appropriate.
State may make closing remarks.
So, Your Honor, to this defendant is charged with a first-degree felony, as the state has laid out. If the court finds that the criteria are met, this is a must situation. So the state does believe that it has proven that the defendant is presently charged with a dangerous crime, again, as laid out in the motion and in the statute. Trafficking in fentanyl is specifically carved out as a dangerous crime and listed on that list. The state does believe that it has proven that there's a substantial probability that the defendant committed the crime. As has been testified to, they responded for the theft call upon a further sniff of the car where the two people suspected of the theft were. They discovered, the Okaloosa County Sheriff's Office discovered that magnetic box with the large amount of methamphetamine and fentanyl in the box. As testified to, they did know that that's defendant's car. It's registered to him. As testified to, there was video at Walmart of him getting out of the car, and the deputy has even testified that he saw him reaching down in the area to where the magnetic box was in that same video. And it was on the driver's side where the defendant got out of the car in the video that the deputy testified to. In addition to the large amount of narcotics contained on the defendant's car, the testimony that the defendant was receiving to the cell phone that he identified as his and he had possession of when he was detained, was receiving text messages that indicated that they needed indicating sale of narcotics. Your Honor, the factual circumstances of fentanyl, of the trafficking of fentanyl do indicate a disregard for the safety of the community. As this court knows, fentanyl is a highly dangerous drug. Indeed, the state submits that because the defendant, there's a substantial probability that the defendant did traffic fentanyl, that there are no conditions reasonably sufficient to protect the community, and the state would, at this time, ask the court to take judicial notice of a federal case, which the court can do. It's case 3:22 CR 00076. Your Honor, the defendant was recently had a violation of federal supervision and was sentenced recently to 14 months in the Bureau of Prisons. And if the court looked at this case, the underlying charge is possession of a firearm by a felon. The state has a printout of the judgment for the court, if the court would like to see the judgment.
Your Honor, the defense also has been given a copy already, so we don't have any objection to the state providing this.
Very good.
Your Honor is going to see that that order sentencing him to 14 months in the Bureau of Prisons with credit from a certain date was just signed in March of this year, Your Honor. So he was just sentenced to the Bureau of Prisons in March for an underlying violent felony, being a felon in possession of a firearm. Your Honor, he also has Okaloosa at least one other felony. Okaloosa County case number 20, CF 977. It is, I'm sorry, it's 20, 02.
It's a 2000.
2000, I'm sorry. It's a CF 977, which was a burglary of a dwelling charge, Your Honor. So the defendant does have at least those two felonies. Your Honor, given that he has just been released from 14 months in the Bureau of Prisons, and then now alleged to have, and the state believes proven by a substantial probability that he is trafficking in fentanyl, the state does believe that he is a risk to the community. There are no reasonable conditions of bond that will keep him, to keep the community safe, and would ask the court to hold him without bond on the trafficking and fentanyl charge.
Excuse me, Your Honor, I'd first like to point out that there is no FDLE lab reports yet. There are field tests, but just speaking anecdotally, I have a number of cases recently where the field test has come back positive for something, and FDLE later comes back negative. So I always want to put on the record that right now we don't have any FDLE lab results for the substances, the alleged substances that were found during the search.
So is there, I understand your argument, is there case law that says that I can't consider it until it's tested by FDLE?
No, of course not, Your Honor. The court is, of course, permitted to consider it.
Not of course, I'm asking.
I do not have case law to present, Your Honor. I just think it is important to point out that the lab results are not yet provided by the state attorney. We right now just have the field test results. In addition, there were at least two other people who had very recently been using the car. So just speaking to the totality of the evidence that we have so far. More importantly, I would like to mention a couple things about my client in regards to the potential setting some sort of cash or professional bond.
Now, each of those two things, you just raised 2 points, but you don't apply either of them to the statutory requirements. If you want me to consider something, I need to understand what you're arguing.
Yes,
I'm
Your Honor.
unclear. You've raised 2 points.
Yes, Your Honor.
the scheme of things, but I don't understand how they're attached, how they relate to the requirements of the statute that they're operating under for pretrial detention, which is
Yes,
what
Your
we're
Honor.
dealing with today, not an underlying trial.
Of course. My arguments, I suppose I should have enunciated more clearly, that the state is arguing that this is a dangerous crime, that the probable cause that my client likely committed the charges alleged, the trafficking in fentanyl, and I'm arguing that the state's evidence does not rise to either that my client is the only person who could have committed the crimes alleged.
Is that the criteria? You have to be the only person?
No, Your
What
Honor.
is the criteria in the statute that you're attempting to elicit evidence on? I would need you to tie it into me if you wish to.
I apologize, Your Honor. I can move forward with my argument as to the bond, if that would be easier.
You can move forward as you wish. I'm letting you know, you're out there talking, but you don't even tie it into the statute upon which you must defeat. And I'm just asking you to please utilize some of the language in the statute if you want me to attach the evidence that you're citing to buttress your opinion.
Yes, Your Honor, I apologize for the confusion. I would like to point out to the court that my client is born and raised in Fort Walton Beach. He has a number of family members here. He lives with his mother in Holt, Florida. He works with his brother, who owns a construction company. His mother has been in contact with our office already. His grandmother lives in Niceville. The one felony in Florida that ASA Sharpless mentioned is from 2000, and my client was a youthful offender at the time. So there is the federal case that you have in front of you. But apart from that, my client's criminal history in Florida is very limited and is from mostly quite a long time ago. He has a couple of misdemeanors since then in Florida, but otherwise just that one youthful offender felony in 2000. My client's family would be able to put together potentially a couple $1,000s for a cash or professional bond. I would like to ask the court to consider a cash or professional bond with a GPS monitor that is a much less restrictive means. Of course, trafficking in fentanyl is, as part of the statute, can be considered, though as always, I will of course be asking or reminding the court that my client doesn't waive any constitutional arguments related to the constitutionality of the statute and setting some sort of reasonable bond. The amount of fentanyl found right now appears to be about 6 grams. Again, once...
What's
I'm sorry,
the trafficking amount?
The trafficking amount is 4 or more. Well, in this part of the part of the statute. So the floor would be 4 grams. I apologize for the confusion in the earlier parts of my argument. I simply wanted to point out that I do believe my client has some defenses in this case. I do think that it goes to the reasons Ms. Sharpless laid out for holding him on no bond. I think my client is a very good candidate for a GPS monitor, given he has strong community ties here. He has a solid living situation, which unfortunately is not a thing that many of my clients can say. He would be able to abide by pretrial services with an ankle monitor if the court would consider setting some sort of cash or professional bond.
Okay. In order to fine for a pretrial detention, there are 4 requirements. And some of the issues that the defense argued did relate to those, but you must tie them with the statute. You can't just have them out in the thin air and expect the court to tie him in. I still don't think it would have gotten you here, gotten where you want to get to today. Because the 4 criteria, one, that it's a dangerous crime, clearly there's been no evidence that it doesn't meet that. Trafficking in fentanyl is one of the dangerous crimes that's listed. The factual circumstances of the crime indicated disregard for the safety of the community. Not only is the trafficking level of fentanyl in and of itself show a disregard for the safety of the community, but there's also a massive amount of methamphetamines. And there's every indication of trafficking, of actual sale of not only the possession of it, which is a trafficking, it indicates trafficking, but also the fact that there's other indications such as phone call, some text messages, which, by the way, neither side told the court at all how that was going to come into evidence, because one of the officers said he didn't have permission to have it. The other side, he said he didn't ask, nor did he receive permission to get into the phone, but nobody objected to it when it came into evidence. How is it that that came about? Might have had a good way, but it was not entered in this court, so I have to take it. It came in, nobody objected, and that's an indication of actual trafficking. So clearly, there's a disregard for the safety of the community, and based upon, one, the fact of fentanyl, which is a scourge on our community, and Mr. Camarda, you don't have to deal with it, but I got to deal with it almost every day, people dying with fentanyl. So if you're going to traffic in fentanyl, you better understand in this county, there's going to be accountability. And the first way we can catch you is put you in jail and not let you out until we resolve your case. So the court finds there are no conditions reasonably sufficient to protect the community from the risk of harm to the physical persons. So the court orders the pretrial detention. I will say anecdotally, and I don't want to invite this was not brought up today. The state has chosen for the first time to operate under D5. It is not C5, which the court has ruled that it was not going to address the constitutionality. In other parts of the state, D5 have clearly been found to be unconstitutional. Yet the defense didn't raise that. If you don't raise it, and it's over, this hearing is over with. If you don't raise it, the court's not going to act on it. But I will tell you that there were some very strong orders on the unconstitutional of that and separation of powers in there. So I'm just pointing that out, that you're operating with a statute. You have the opportunity under C5, but the state has chosen to operate under D5 when it has been clearly set forth in multiple jurisdictions in this state to be unconstitutional.
Your Honor, I did mention that.
You mentioned, we did not, what you said is, we're not, I don't know exactly the term you say, you're not foregoing constitutionality.
Yes.
That's fine.
That's all, I just wanted to clarify.
That's
I'm
fine.
not waiving that.
You did say that. Well, you don't ever waive your right to make a constitutional argument.
Of course, Your Honor.
But-
I'd just like to put it on the record.
Well, and you did, and I noted that. But in order for me to address it, it's got to be brought up in a more formal sense. Anyway, get me all fired up. So, get me in order.
Yes, sir.
Okay. Let's go ahead and take a break. And we'll come back and finish the affidavits, and we'll probably roll right into the hearings, the hearings at 3:30, because we'll be on top of that at that point. Thank you very much.